So I'll just start and welcome everyone who is tuning in. Welcome to the first ever Family Law Now After Hours series. We are super excited to have you here. We're super excited to be able to put this on for all of you. For the purpose of this series is a discussion. It's for us to sort of share our perspective, our knowledge. It's really intended to provide general information on separation, divorce, and other family law matters. So it's not to be taken or construed as legal advice. Should you require specific, advice, you can always reach out to our office. You can set up a consultation with us. But this is really just for us to talk about all things family law and get right into it. So I'm just gonna give a little background of who we have on your screen today. So we have Joseph. Joseph's an articling student at the firm, and he's set to be called to the bar in June of this year. So he is a graduate of the Ted Rogers School of Management at Toronto Metropolitan University. So that was Ryerson. And he also attended Queen's University for his law degree. So he balances his, legal passion with his passion for sports. He's a big Toronto Maple Leafs fan, so good, as long as you're not a Habs fan in my household. And he's also a big fan of the LA Rams. And his dedication to family law is driven by a desire to provide compassionate and patient advocacy, believing in the impact it can make during an emotionally challenging time. And as he enters the next phase of his legal career, he's committed to positively influencing the lives of those who are facing, the difficult situations that arise with separating families. So then we also have Shanza on your screen. Shanza is also a recent law graduate. She graduated from Osgoode Hall, and she currently serves as an articling student with us as well. And she will be called to the bar in June of 2024. So she's focused on launching her legal career in family law and is dedicated to providing an empathetic and proficient legal support for those navigating family-related complexities. She has valuable experience, and it stems from active participation in legal clinics, mooting competitions, and prior work as a legal assistant. She's also completed her introductory interdisciplinary collaborative training. So that's a lovely thing that our firm promotes. Most of our associates are collaboratively trained, and as she embarks on her legal journey, she's poised and she's ready to contribute to the firm's commitment to excellence in family law. And then the OG himself, Russell Alexander, the founder and
The
senior.
guy with the gray hair falling asleep. Yeah, right.
Yeah, so our fearless leader here at Russell Alexander Collaborative Family Lawyers, he has over 25 years of experience, and he uses his knowledge and expertise to serve his clients in all aspects of family law and to help them cope with the difficulties of separation and divorce. He uses his experience to create unique solutions for each client and to enable them and their families to move forward and support them through the transition of these, divorce and separation proceedings. He has written 4 books, big author over here, and he is, again, fully trained as a collaborative practice lawyer. So you can always tune in. He's always doing conferences, and
They were comic books. They don't count.
they were
Come on.
comic books. Massive font, big
Right.
font. Exactly. No, they're a great read. If you haven't picked up a copy, I highly recommend that. And then there's me, Stephanie. So I've been with the firm since 2018. I was called to the bar in 2022, and I am now an associate lawyer at the firm. So I completed my undergraduate degree at Queen's, and then I attended Liverpool, go Liverpool FC, for my law degree. So I graduated with first class honors from the University of Liverpool. And outside of work in the legal world, I like to travel, I like to be active. I hate the cold weather, so I'm extremely happy February is not freezing. So every chance that I can to travel, I take that. So without further ado, let's jump right in. We have a couple topics, some questions that came in previously, but this series today is going to be focusing around understanding the divorce process in Ontario.
Mhm.
So, Joe, I'm going to shoot it right at you. So, what are the grounds for divorce here? So, what's
Yes,
no fault divorce? Tell us about it.
sure. So, in Canada, when we're dealing with married spouses, our guidebook, our rule book, so to say, is the Divorce Act. That's where we go to for a lot of our answers. And the grounds for divorce are actually found in that act, specifically at Section 8 of that act. And basically, the legislation states that a grounds for divorce in Canada constitutes a marriage breakdown. So there are three methods which sort of can demonstrate such a breakdown. The first being that the parties are living apart for a year. The second being one of the parties are facing cruelty. That cruelty can either be physical or mental. And the third is that the parties are dealing with adultery. So the main ground, um, more so of which is the least burdensome to prove in terms of evidentiary requirements, is that the parties are living separate and apart for a year or more. So what does that mean, separate and apart? Basically, that just means that the parties are ceasing to live and reside in the same household, and they are ceasing all social functions with one another. Um, Basically, this pathway is commonly chosen for its simplicity and it allows the parties to have a fresh start. So, there are provisions for couples to live together up for 90 days. That allows for the parties to reconcile with one another if they have a second heart or they want to really try to refocus and rekindle their relationship before proceeding with an official divorce. And as well with that, in order to seek a divorce, the parties do have to live separate and apart for that full year. So if the parties, the two married couples decide to reconcile and the days that they choose to do so exceeds the 90 days, that clock starts fresh. The other two grounds that I mentioned previous, physical or mental cruelty and adultery, both of those two require a lot more substantive proof or evidence that can show that this truly is the case. So compared to living separate and apart, this does have a greater evidentiary burden that one of the parties has to sort of persuade the court that this is the case. And with these two grounds, both cruelty and adultery, if the court is satisfied that this is in fact the case, it's going on in the relationship, then they can grant a divorce immediately, as opposed to the 1 year wait period that occurs when the parties are living separate and apart. And I do want to note, however, that you do not necessarily have to have the evidence to suggest that you are, living in an abusive marriage. And if you or your children are in danger at any time or in an unsafe situation, then it definitely should be reported. And there are ways that us as lawyers can help remedy those situations. And going back to what Steph mentioned regarding no fault divorce, in Canada, that is something that the legislators made an emphasis on when drafting. And this emphasis is highly recognizing of the breakdown of a marriage and that it can happen without blame and without it being truly the fault of one party. So, what does that mean? There's no finger pointing, no he said, no she said with respects to why the marriage fell apart. And really, what's great about this paradigm shift that we've seen over the last few decades truly reflects the reality of such circumstances and that marriages can just break down naturally. So, really and truly, the no fault divorce also incorporates, like I said, avoiding the blame games. And it just goes back to the fact that a marriage in itself can just fall apart.
Yeah, and I
Yeah,
think
that's
it's
that's a great summary. The only a couple things I would add, sometimes people live separate and apart under the same roof, right? So they can't physically afford to be separate. So that might be count, you might want to consider that. And lots of clients come to me and they want to choose one of these other grounds, right? He cheated on me or she cheated on me and I'm going to prove it. They're denying it. The effect, though, of having a hearing is you're going to be 18 months, 2 years into it. If you've been separated for a year, you can just get your divorce. And lots of people think, oh, well, if I can prove this infidelity, then I'm going to get the house or I'm going to get a bigger settlement. It's a no fault system. Nobody cares. They want you to move on. It's not going to affect the outcome in terms of substantive property rights or support. But that was an excellent summary. Thank you, Joseph.
And Russ, you brought up that, two people can still live separate and apart
Yep.
under the same roof in the same dwelling. And that was actually one of the Q&A questions that we had. So we were going to speak to that a little later. But
Yeah.
now that you brought it up, I can sort of dive into that. So what's really great about two people, and yes, they still can legally separate while living together. That is possible. The courts, through various case law, have suggested that there's sort of these two conditions that must be met to establish that you are still living separate and apart, because you don't want that timer to restart, right, in order to grant that full year separation. So in a lot of the court cases that have come before judges, they've sort of drawn this distinction that there must be a withdrawal from the matrimonial obligation with the intent of destroying the matrimonial consortium, as well as physical separation. A lot of big words, but pretty much what that means is that basically, if there's an unhappy household, there has to be the withdrawal of the matrimonial obligation. So that means services for each other, shopping, cooking, laundry, that sort of ceasing to exist, as well as the physical separation. So that can mean separate bedrooms, often not having sex with one another, eating meals separately. It's just living your lives separately.
And the other thing, we see the Hollywood movies, right, where one person is refusing to sign the court papers, right? This is the dramatic scene, right? Hollywood loves to dress this up. Nobody cares. Like in Canada, it's a no fault. If as soon as one person decides the relationship's over, that's it. They don't need the other person to agree. So that could be, you could send a text message, you can hire a lawyer. It's good to have some kind of evidence to show this is the particular date that you're separating, because it may affect property division later. But you don't need the other person's consent, or what you see in Hollywood where they're refusing to sign the papers. You just proceed without them. So lots of nuances in here that's different than what you see in Hollywood, right, Steph?
It's never how they show in the movies. That's
never as exciting. Yeah.
Never as exciting, I was going to say.
Yeah. And when it comes to filing for divorce, like you said, Russ, only one party really needs to take that step. And Shanza, I mean, this kind of leads right into what you were going to talk about with us for filing for divorce. What's, the necessary forms? Because, not everyone plans to deal with filing for divorce, right? That's never anyone's plan. So what forms do they need to sort out?
Okay, yes. So to initiate the divorce process, you do need to complete specific forms. Most of the time, you will start with the application. The application is where you make your claims against the other party. Now, what I mean by claims is it includes things that you are seeking with your divorce. So that could include if there's children, it could be proposed child parenting arrangements. It could be child support. If there's property involved, then you make claims related to property division and equalization. You can also ask for spousal support if that's something you are claiming. So all of this is what goes in the application form. And this is kind of your way of bringing your narrative to the court. Once you file and serve it, the other party, they get the chance to file their answer, and that's how they get their side heard. How the form is drafted is you check off these boxes for various claims that I just mentioned, and then you kind of provide grounds for them. There's also other forms that you might need to provide. There's financial statement, and financial disclosure is really important in divorce proceedings. A financial statement is filed when the claims that you're bringing relate to property or support. So that could be child or spousal. There's two types of financial statement forms. So depending on the type of claim that you're bringing, you file the appropriate one. If you're seeking parenting orders, for example, then you have to complete an additional affidavit 35.1. This form kind of sets out things like how you plan on caring for the child and the people the child will reside with. So it differs depending on the case, what forms might be filed. The major one I will say is the application, and then that's followed by all the other forms depending on the claims that you're bringing.
Yeah, so there's a lot of paperwork and things that, you might not ordinarily be familiar with.
Mhm.
So when you're seeking an actual just the divorce, if you're not really worried about like what Shanza was saying, pursuing other sorts of claims like property or support or division of assets, things like that. If you just want the divorce, that's when we're looking at just a simple divorce application or a joint divorce application. So sometimes couples will choose to, proceed with a separation agreement first, and once all the terms that they've agreed to are drawn up nicely in this nice separation agreement, the only thing left is the divorce. But you do have to go to the courts to be able to grant that. So, in a simple divorce, for example, one party can file the paperwork if the other party doesn't contest it, and it can proceed, um, you know, as simply as possible, hence the term simple divorce. In a joint divorce, both parties can file together, hence the name joint divorce. Both of them can be uncontested, they can be amicable, but the joint divorce application does require the cooperation of both parties from the beginning. So, like I said, if you're only seeking a divorce, the simple route may be the most beneficial because you're not really claiming any other relief. But if you want to include things like child support, provisions or agreements, parenting time provisions, spousal support, all of these details, and that you and your spouse are on the same page with all of that, and you want it to be included in your divorce order, then a joint divorce application may be more applicable to you. In my experience, I mostly see simple divorce applications because a lot of the parties have come to an agreement or a settlement agreement, or there's already an order. What about you, Russ? What do you typically lean simple, joint?
Yeah, I don't know if there's anything as that's just the title of the document. There's nothing simple
Oh,
about
no, no, no.
divorce. But I do want to talk about that. But there's also fees, right? That you got to pay along the way. So you've got these forms. So I just did a quick search on my phone. Our law clerks could tell you, and the schedules change all the time. File the application. This is what you have to pay to the government, not your lawyer. This is the filing fee. Is 214. File your answer to the application, 171. Where if it includes a divorce, 214. Placing it on the list for a hearing, another 445. Summons to witness, 33. Um, there's a whole schedule of fees that have to be paid. So oftentimes when clients come to us, we'll say, okay, well, if it's simple, meaning we're not answering any claims, we'll do it for a block fee. But most of our block fee has to go to the court to cover the filing fees. We pay it for you, so you don't have to write a check and then you pay us back later. But I just want to talk briefly, thank you, Steph, about this idea of a simple divorce. And I see this all the time when clients come in and say, yeah, no, we've been separated 3 years. No, we haven't done anything. I'm got a new partner. I want to get married. Get me a divorce, right? Okay, serve the divorce papers. And then the answer comes back. There's a claim for spousal support. There's a claim for property division. They want to sell the home. They want to divide your pension. Your simple divorce has now gotten very complicated, right? So the other party may come back and make claims against you, and it's no longer simple. It's simple in the sense that you've settled everything and you've agreed to the terms, and you could just simply file it with the court. That's okay. Possibly a judge may still stop and say, what provisions are in place for support for the children, and deny your order until you explain if child support is being properly paid. So lots of little nuances in all these documents and lots of traps and pitfalls that we're going to talk about. When you think I'm just getting a simple divorce, well, surprise, now you're going to have to pay spousal support for 20 years or whatever the claim may be. Or in common law, well, that's a different subject for a different day. We'll come up with common law issues as well. But thanks, Steph.
No problem,
Don't get
Russ.
me going.
I know Russ can talk about this for hours. It's, your pool of knowledge, and like you said, simple divorce, although the courts think, oh, it's simple because it's just the divorce box that you're checking off,
Right.
that can quickly become not simple at all.
Yeah.
Yeah.
Exactly. Yeah, and I know, Joseph, you sort of already touched on the grounds for divorce, but who can apply? Like, what are the legal requirements for applying for a divorce? Can I,
Yeah.
I've lived in Sweden my whole life. Can I come and apply for a divorce here?
So the government's very strict in terms of who can file for a divorce. Well, since we're in Ontario, we'll talk about Ontario. So there are three requirements that are laid out. The first being the 1 year residency in Ontario. So one of the parties has to be here for a minimum of 1 year, and that will allow the divorce to at least commence, to be initiated in Ontario. Canadian citizenship isn't mandatory. You don't have to be a permanent resident of Canada. As long as you are here for a minimum of 1 year, that checks off the first box. The second requirement that they ask for is proof of the marriage. So, what does that mean? Both parties must be legally married in Canada, or a marriage could have taken place in another country. However, that marriage has to be recognized by Canadian law. So, that's also really important. The third, um, going back to what I discussed, the grounds of divorce, that has to be prominent. That has to be known. The court needs to know why they should grant you this divorce. So that goes back to living separate and apart, facing cruelty, or dealing with adultery. So once you have all three of those requirements in place, you've met all three of those boxes, you've checked them off, then that will allow you to initiate those proceedings.
Awesome. And how can we help, right? As lawyers, as a law firm, how can we help people navigate this process? I know Russ already discussed how there are these nuances that you may not anticipate that just jump scare and just come out of nowhere. So Shanza, like, what's if someone needs help to go through this process, what would our role be? How can we help them?
Yeah, so if you have legal representation, then you have someone who is familiar with the laws, knows the rules, knows the court system. Having a lawyer can guide you through the whole process. They can explain you your options, give legal advice. They can evaluate your situation, access the strength, the weaknesses of your case, of the claims that you're bringing, and they can provide you advice on potential outcomes, whether it is a good idea to spend thousands of dollars arguing for one thing over the other. Um, and I would say an important part of having legal representation is that a lawyer can talk to the other side and try to work out an agreement and negotiate on your behalf, which can be very helpful in settling things faster and outside of court. The lawyers can We can negotiate and we're trained to do it. And if you have a lawyer, they can make sure that if you are entering into any settlements, that it is fair and that it protects your rights. um, there's also different, like, out of court avenues that lawyers can explore. Like, if there's children, there's parenting plans, professionals can come in. There's collaborative, there's mediation, there's other ADR. And if you have a lawyer, they can guide you on what the best course of action could be for you. And in that way, the case doesn't have to go to court. And even from a cost perspective, that is something that can be very favorable to the clients. In any case, if your case does end up going to court, then if you have legal representation, the lawyers are there to advocate for you. There is so much that comes with going to court. There's drafting of documents, there's filing, you know, make sure you do it timely, attending case conferences, and just having representation can help you through all of that.
Yeah, this
Yeah.
this process can be overwhelming, right? The emotional component of a separation and divorce is one thing, but then navigating the court process with, strict rules, like we have the family law rules that not everyone just reads casually for fun. I'm not sure if anyone just has, some
We
light
do.
night. Yeah, that's something that's, it's if I could get it on a Kindle, it would probably be on my Kindle.
Yeah.
But yeah, like navigating the process, there's so many things that you need to be mindful of. Time restrictions, there's certain timelines that you have to adhere to. Even just the decorum in court, how to address the court, how to address opposing counsel, rules about what's allowed in an affidavit, all of these nuances that unless you do it every day and you practice it, you might not know it. So Russ, our veteran, court attendee, what if you do go to court? What can we expect?
Yeah, let's talk about court in a moment, but just in terms of the roles of the lawyers, keep in mind there's 8 judicial regions in Ontario. Each region has their own practice direction, which is another set of rules, which may be difficult to find. But there's this Netflix documentary called "The Fog of War," and what they talk about is unknown knowns. So by getting a lawyer involved, right, you're going to get some dispassionate, objective advice. They're going to know the local process, whatever community that you live in. They'll likely know the judges and how they'll decide certain cases. So you're gaining that experience. But like Shanza said, there's a lot of things happening here. Limitation periods. So you may have a valid claim. If you wait 5 years to bring it, it might expire in 6 years. So your claim may expire, and then you got a whole new set of problems trying to set aside a limitation period. Potential claims. You may have claims to assets that you don't know about, and that brings in disclosure issues. When we say disclosure, we want to understand, what assets and what support is available to share. And if you don't know the right questions to ask, you may not come up with the correct income. Like Joseph said, and Stephanie said, there's legal implications for each step that you take. You may not appreciate what those implications are, but your lawyer is going to coach you through. It's like the hero's journey. Your lawyer is the guide. They're there to guide you through this process and provide you with a path. But the client's the hero, right? They're the ones going through the hardships and facing peril at each step of the journey. Risk. Lawyers help manage risk. Like everybody's saying, there's costs associated with taking these steps, not just financial costs, but emotional costs too. I know clients, they've been in litigation for 2 years. It hangs over their head like a dark cloud. They can't sleep at night. They're physically unhealthy. They're stressed out. Some are suicidal. So there's some serious physical and psychological costs to this whole process. So your lawyers may not actually be able to help you with those aspects, but they can connect you with your family doctor or other professionals who can, and they know what services are available. So those things are things that you want to claim. But getting to your question, Steph, in a very long about way, sorry. Court involvement, what to expect when your case goes to court. First of all, expect the unexpected, right? It's not going to be the Marriage Story movie that you see on TV. It's not going to be anywhere near as exciting or as dramatic as that. You file your claim and then you wait. There's time, there's a deadline. There 30 days to respond, then they file an answer. And there's another waiting period. And then you may not like what the answer says. So you file a reply to dispute the parts of the answer that are new or that you don't like. Then you may file an affidavit, you may bring a motion. You're going to be subject to case management if you're in the Unified Family Court, which is the Superior Court of Justice. So ideally, you have one judge managing your case from start to finish. The great thing about that is they know what orders need to be made for disclosure. They get a sense fairly quickly who's playing games and who's not following the rules. And they put your case on a timeline or a fast track or whatever the circumstances may require of your particular case. Then there's conferences where judges will make recommendations to settle a case. The lawyers will file briefs on your behalf indicating what they think the outcome should look like and what the legal issues are. Based on those briefs, the judge will make a recommendation saying, here's what I think the outcome would be. if I had to guess, I'd say close to 70 or 80% of cases resolve at that stage. They hear that the writing's on the wall, the judge has said what the outcome is, and they settle. Very few cases go on to trial. It's very expensive, and there's not that many novel legal areas of law. Last thing you want is a new area of law that you want to resolve, because it's going to go to trial and then probably go to a court of appeal. It'll be 2-3 years to get it resolved. If you have a clear set of facts and clear law, the judge will tell you what the outcome is going to be, give you some goalposts in terms of what a range of settlement would look like, and then your lawyer would negotiate a resolution based on that. If you're going to trial, you're going to be over 2 years in court. Some jurisdictions, just to get your first court date. So you file all your documents, you do something called a Rule 39 hearing, the clerk checks your documents. Then you'll go to a case conference. That first case conference date in many jurisdictions is several months out. Might not be until next year until you see a judge. So that's what you can expect. And that's why we all encourage people to look at collaborative practice, mediation, negotiation. All the lawyers on your screen today have collaborative practice training. These are young guys and new professionals coming into the profession. I've been doing collaborative practice for several years. I find that people who settle their case are much happier with the outcome because they can control the result. A third party, namely a judge, doesn't know you very well other than the material you filed with the court, and may never meet your children, are going to decide what your family's outcome is going to look like. And most parents acting reasonably want to be the ones who make those decisions. So that's my take on going to court. Some cases need to go to court. Some spouses will want to burn everything to the ground. They're upset. They want retribution. They feel wrong because there's infidelity, domestic violence. The family court isn't the place to dispense retribution or punishment. It's there to divide your property and allocate support and parenting time in accordance with, the Divorce Act, Family Law Act, Children's Law Reform Act in Ontario. It's not there to give you compensation because your feelings are hurt, or that your spouse misled you, or that you found a sexing text message and now you want to exact punishment. Family court's not going to help you. The other thing I see a lot of, lots of spouses think their other spouse is a narcissist, and they'll do anything to prove it. And they think that's the magic bullet. If I can just show what a narcissistic person this is, the judge will see that I'm right and I'm going to win. Well, again, that's not going to affect the outcome of your cases. So again, follow your lawyer's advice. Take programs like we're offering tonight to learn more about the process. Lots of resources we're going to give you the next couple of days in terms of where you can learn more. But that's sort of a shorter summary of a much longer. We spent a whole hour talking about that one stuff. Thanks for giving me that one.
No, and exactly what you said, Russ. I think, this kind of leads into a question that we got about, and I really get almost every day, like, how long can this take? How long is it going to be? And how much is it going to cost? And the answer, always the good old, lawyer answer, is it depends. It truly depends. It depends on how cooperative the parties are. It depends on.
That's the only word you need to know if you're a lawyer, right?
It depends, right? There's so many factors, and that's why alternative dispute resolution, what Russ and Shanza talked about, mediation, arbitration, collaborative practice, that's the benefit of using those alternative dispute resolution, or ADR, is because you have that much more control over the timeline of your matter, the productivity of your matter. With collaborative practice, I'm sure we'll eventually do a series on this, but you can have other professionals involved to help guide you, and it could be a cost-saving tool, and even just to have a neutral third party to help two parties somehow compromise on one issue, the other issue, whatever the case may be. So if you're ever going to ask, how long is this going to take? I can almost guarantee that your lawyer will say it depends. And that's unfortunately the only answer that we can give you, because
I
it
wrote
truly
some notes. I wrote some notes up, and my first line was, "It says it depends."
100%, because everybody's case is
Yeah.
different. There's so many different factors and disclosure that has to be, navigated through, like you said, Russ. So unfortunately, I can't give you much more than that. So
I think that's
I
one
do.
thing though, Steph, that people think that, they come see a lawyer and everything's going to be, cut and dry, all done in a couple months. It's not the case. It's never the case. The divorce itself, just to process with the government, takes 6 to 9 months. So you're already waiting for that. And if there's, like Russ said, if you get an answer back and there's things that you don't agree with right then and there, you add an extra few months. So it, like Steph and Russ and everyone said, it does truly depend on the circumstances. But just know that it's not going to be cut and dry, finished in a couple weeks.
Right. Yeah, it's not a drive-through, that's for sure.
No.
But just a couple things I want to add, Steph. Those are really great points, Joseph and stuff. Think of costs not just in terms of dollars. And I mentioned this earlier, right? You've got what I say to the clients who are being obtuse. Do you want to walk your daughter down her wedding aisle in 20 years from now? Or do you want to be the couple where you can't both show up at the wedding? Right. That really grounds some of the costs that we're looking at. The emotional costs, the physical costs, the cost to your children of not cooperating through this process. But in terms of that point, the cost is going to be driven in large part by the legal advice that you get, the process that you choose. So we've heard, you've got a taste today of what it's like going to court. You could be 6 months would be quick, in my view, just to get the documents at the door, even if everything's simple and the paperwork gets to the counter and is correct. It goes into a basket and you got to wait for the judge to get to it. And then they're going to issue the order. And then the court's going to take a few months to produce the order. And then there's a waiting period to get for the appeal to expire. There's an appeal. So 6 months, I think, would be fast, super fast, but up to 2 years, depending on what you're looking at. And probably, in my experience, the most important thing that's going to affect costs is the lawyer that your spouse chooses. So, there's certain themes that we see when you've been doing this for a while. Some lawyers are firefighters and peacemakers. They want to resolve disputes. They want to treat people with respect. They want to focus on their client's goals and interests. Other lawyers, their worldview of themselves is, I'm a warrior or I'm an arsonist. I'm going to burn everything to the ground. I'm not going to settle this case until the money runs out. I hate to say it. There's some people like that, right? They grind the file. So depending on the lawyer your spouse chooses, that may limit your process options. If they're not collaboratively trained, you can't do a full collaborative practice process for your divorce. Or if they only do trial work, you're likely going to trial. You're not going to want to settle the case. So what we try to encourage really early on when clients come to us is to encourage and educate their spouse in terms of process options that are available, and then pick the right lawyer, have that spouse pick the right lawyer for whoever they want to choose, but we just give them as much education as we can. Thanks, Steph. You want to get on this, Shanza? I'm kind of stealing your thunder here.
Yeah, and even when we, that kind of ties into what steps have to be taken. Once you have, each party has a lawyer, and hopefully your spouse's lawyer retains counsel that's like-minded in terms of settlement and managing the file and as amicable as possible. One of the first things that will come up and is usually top priority for parties is what happens with the kids. What can we expect when we're looking at the children, and how is the divorce going to impact them? And we hear the terms custody and access used, the law has changed. So now they've tried to simplify the terminology to sort of go, there's the two components of parenting time and decision-making responsibility. And Shanza, I know you're prepped to kind of go through, like walk us through what that entails.
Yeah, no, thanks for the start, Steph. I will go into these new terminologies and what they mean for parties who are separating. So when parents separate, the first thing they want to do is they have to resolve how they will continue to make decisions and have contact with their children. There's also the financial part of it, which is the child support. I will start with talking about parenting first. So for parenting, as Steph mentioned, we have the two terms. So the two concerns with parenting that come to light are parenting time and decision making. Parenting time is how much time each parent gets with the children. Um, there can be so many different arrangements. They can differ quite a bit. The children could be dividing their time equally between the two parents, or one parent can have primary residence and then the other parent gets secondary parenting time. There's so many different arrangements that can work out for it, really depends on the couple and the children and their schedules. Um, for decision making, again, it can be shared or it can be exercised by one parent. Um, or there could even be a split between major decisions. So, for example, one parent gets to make decisions related to education, and the other anything related to health. So there's different arrangements that can come in for decision making as well. Um, so these are the terminologies that address parenting. And how it works out post separation is separated parents will end up entering into a parenting plan. Um, it's perfect if you are able to work out a voluntary plan, reduces conflict for the children. Lawyers can help with that. Um, Usually, if a parenting plan is reached, then it can be incorporated into the separation agreement, and then it becomes binding on both parties. If the parties end up going to court because they can't come to an arrangement, um, then you're looking at the courts, and the courts look at the best interest of the child. Um, and in order to determine best interest, there's a number of factors. There's a whole test for it. I can name a few, so it depends on the age of the child's relationship with each parent and their siblings. History of care is an important one, and the ability of each parent to meet the child's needs. There's a whole list. There's also family violence, so the court will consider that as well, and they want to make sure that the child is safe with the parent if they do have parenting time. Um, so the court will look at all these factors and in order to come to a decision in terms of what's the best parenting arrangement and whether there should be joint decision making or not. Um, I'll talk a little bit about child support before I stop. Um, so for child support, we do have the federal child support guidelines. They calculate how much child support a parent owes. So there's the basic monthly payments, and then there can also be additional special or extraordinary expenses. So these relate to any special needs or any extracurriculars the child is involved in. The monthly child support amount from the guidelines is calculated based on the income and the number of children. Now, which parent pays the child support? Um, if the children live primarily with one parent, then that parent gets the child support from the other parent, depending on the incomes. If there is equal parenting time, there may still be child support owed. And again, that depends on how much each parent is making and then the standard of living in each household. Um, I'll just say that child support is legally enforced in Ontario. So it is your child's right, and it's a legal obligation on you, on the parents, to pay it. So it's a bad idea not to.
Yeah, 100%.
Yeah.
I can't, you know, I there's been several instances where, parties that want to maybe opt out of child support, and we have to tell them you can't contract out of it. It is the right of the child. Exactly what you said, Shanza. Like it's legislated. It's table amount is table amount. Section 7 or special and extraordinary expenses. Those have to come into play as well. Russ, I know you were. Did I cut you off there?
No. Well, we mentioned earlier, the judge isn't going to give you your divorce unless there's provisions in place for the children that satisfy the court. Now, there could be a shared parenting regime that increase costs, travel costs, and that could be a reason for not paying guideline support because you're spending, $100 in fuel each time you go on a visit. So there are some circumstances, but when Stephanie says section 7, she's referring to a particular section of the child support guidelines. The other thing I just want to add in terms of parenting, there's voice of the children. Let's just say there's a dispute. You can get a voice of the child's report depending on the age. Seems to be the flavor of the day in the court, where we'll have the child's views and preferences communicated to the parents or to the court through a third-party professional, usually a social worker trained to deal with children. Could be through the office of the children's lawyer. They can appoint somebody to investigate and provide recommendations regarding parenting. We can use other professionals. Lots of times in the collaborative setting, we'll have a family professional develop a parenting plan for the parents, even before the professionals meet. So the lawyers sit down and meet with their clients. We have a draft parenting plan to consider. And if it meets our client's goals and interests, we can execute it right there. And then you have your parenting done. And that's done outside of the court system. It can be done fairly quickly within a few weeks, depending on everybody's schedules. So there's other professionals and other factors to take into account as well. Lots of tools in the toolbox when dealing with parenting and contact orders.
Yeah, 100%. And it's always beneficial when you have parties that are on the same page, and are really child focused through the process.
And we'll try and include a link to the child support guidelines. So for everybody watching, you can go online and look at the guidelines, and that's provided by the government.
Yeah, 100%. So I'll just sort of switch gears a little bit now. We talked about children and, parenting and support when it comes to the kids. But another key component of every, every divorce proceeding is to take a look at if there needs to be a division of property. So what sort of to circle back to what Joseph was saying earlier about your date of separation, when did you decide? When was there, a decision that there was no chance of reconciliation? That date can be very, very important when we're looking at how to divide your assets. So what we do is we look at all of your assets for each spouse. So all of your assets and your debts on your date of marriage, kind of take a snapshot, like a financial snapshot. And then we take the same sort of snapshot on your date of separation. Everything between those 2 points can be equalized. Of course, there are exceptions, gifts, inheritances, and that's why having, a lawyer in your corner is helpful to navigate, if there's any excluded property, if there's any date of marriage deductions that need to be taken into consideration. But what happens between those 2 dates is we look at how much wealth each spouse has accumulated or over the course of your marriage. And typically, one spouse will have grown or have a higher net family property value than the other spouse. So you sort of have two people that are sort of balanced, maybe not as equally. So the equalization payment that would be owed through this division of property is you take the spouse with the higher net family property will pay the spouse with the lower net family property half the difference. And the sort of mindset of that is that both parties are walking away from the marriage on more equal footing. Now, there are always exceptions to the rules. There are always exceptions to the rules.
Always.
Always. And that is just like it depends. There may be exceptions. You know, we may have to look at are there any assets or any debts that should be excluded? Would it be, unfair or unjust to do an equal division? And in that sense, maybe that net family, that the equalization payment needs to be readjusted. So that's why, when you're going through the process, we can share with you sort of the legal framework, but when it comes to your specific circumstances and how to navigate, what you could be entitled to, what you might be obligated to provide, that's why having a lawyer in your corner to navigate those nuances is really helpful. Um,
Steph,
yeah,
you summarized 3 years of law school in 2 minutes. It's incredible. Amazing.
I need to write a book now.
Yeah.
Yeah. We use language like equalization and net family property. It's just a fancy way of saying how you're going to share your stuff, right? And like Steph says, there's lots of little nuances you got to be careful about when doing this calculation. Married couples enjoy a greater bundle of rights than common law couples in Ontario. Common law is a whole nother topic that we're not talking about today. But the other thing I would throw in there, Steph, is maybe short marriages. You want to consider that. If it's under 5 years, maybe we're not going to share equally. Maybe an equal share would result in an unjust outcome. And the only other thing I'd point out, because there's so much, again, we could talk about this for days. The matrimonial home, the home you guys live in, have special rules attached to it. So if I brought in a home to the marriage, and I had that prior to the marriage, and we separate, and that's still the same home, I'm going to share it. I don't get a deduction for it. But if I sold it and bought a different home, then I'd get a deduction for the first one. Only lawyers would dream up a scheme like this. All I'm trying to say today is complicated, get legal advice, make sure you get it right.
100%. And I truly believe we could do an entire hour, an entire week on property division and nuances and a topic just on excluded property, just on date of marriage deductions. So that's why
You could do a day on the matrimonial home.
100%.
You can have more than one.
Matrimonial homes can you have?
Your cottage could be a home, right?
You
have
can have
multiple
4
homes.
matrimonial homes.
That's right. Those are good problems to have, but it's a problem, right?
100%. So I do want to be mindful of the time. I know we have, one more topic that came in that I definitely want to hit on. And Joe, maybe you can touch on this for us is post-divorce changes. How can parties handle the changes in the circumstances post-divorce?
Yeah. So obviously, life isn't perfect. Life can throw you curveballs. Someone can be let go or fired, terminated from their employment. A whole magnitude of things can occur. And you may be stuck saying, how do I go about this? How does this change what's already been dealt with through this judgment? The first step anyone can do is have a open, casual conversation with your ex-partner to try to resolve the issues. That's number one. Obviously, it's easier said than done if you both are amicable. That may not be the case, but it can never hurt to have an open conversation to try to resolve something. Second step, I would say, is I would refer to the separation agreement. So if you were able to draft or had a separation agreement drafted, or you could also look to a court order, but more often than not, it would be in the separation agreement. You would sort of find your answer. More specifically, if it was drafted well, then there would be a dispute resolution clause. And that dispute resolution clause often is included as a guide for unexpected changes. So like those curveballs that I mentioned. And there can be instances of mediation, arbitration, med-arb, or even a parenting coordinator. And they can serve sort of as those referees that you can go to bring your issues and hopefully get them resolved. in the sense that maybe those provisions are not in place or mediation does not prove to be effective, then obviously the last resort is the court. And the court is what's called the ultimate referee. They make the final decisions. Sometimes too, if your separation agreement is drafted really well, there could already be a procedure that's been put in place for reevaluating child support or spousal support. Those are great to have, but like I said, separation agreements, sometimes they're drafted by yourselves and you don't think that far ahead. So that's why it's really important to get legal advice when you are going through a separation to make sure that the separation agreement that you have done and that is drafted is well written and provides those procedures to reevaluate things like child support when incomes change. Like I said, if you're one of your spouse, you or your spouse loses their job, how to sort of reevaluate that and see whether or not spouse support now comes in place. Those are all really, really important.
Yeah,
Yeah.
100%. Like you said, life is unpredictable, and it's always better to have advice, legal advice, that we deal with this every day, right? We can, to the best of our ability, set you up for success if something needs to change in the future. How do you approach something? Should something go differently? And yeah, it's always great. Hire a lawyer. And I do want to flip it over to you, Russ. I believe we
Well,
had
we've got a
question.
couple questions coming in. We're going to get to in a minute. That was a great summary, Joseph. Just want to add a few points. You know, lots of people don't like the outcome of their hearing and they rush over to our office and say, let's appeal this decision. That's an option, but appeals in family law are fairly rare. The appeal court shows a lot of deference to trial judges. So they really have to get something wrong before that's going to be successful, and it's expensive. You want to think about material changes in circumstance. This is language lawyers use. So if you're 6 months after an order and there's the material change in circumstance, that may justify a review of that order. But that's the test you're going to need to make. There needs to be something new that didn't exist 6 months ago that would explain why this particular order is no longer working. And there are circumstances like that, but it's not, a court's just not going to change the order willy-nilly because you don't like it and it's 6 months later. You want to consider orders that have review mechanisms in place. So child support is usually adjusted annually based on income. So that's going to be a review of the order. Spousal support could have adjustments based on income, based on retirement, based on a number of factors. So that could be considered. You want to look at the order or the underlying separation agreement and ask yourself, is there a dispute resolution provision to this? Can I conduct a review based on that provision of the order, that section of the separation agreement? And that could trigger a review. Mobility are issues we see quite often. You know, the economy's changing, people moving different regions out of the country. A move of a child outside the jurisdiction where the order was made can trigger review. There's provisions in the Divorce Act to provide notice and create onuses, but this could be another trigger that we see sometimes. And the other point I would just want to add is we want to be mindful of capacity issues, right? Did this person enter into the agreement voluntarily? Was there proper disclosure? Could they make an informed decision? Those are factors lawyers look at in considering whether the existing agreement or order should be reviewed. So lots out there. If you want to make a change, it might be, there could be an avenue to get the order changed, but it might not be an easy avenue to take. That's all I would add, Steph.
Thanks, Russ. Let's see here. I do see some questions that have popped up. Russ,
and
do
I
you want
told some of the online questions we're going to get to them, so that's great. Thanks for sending in your questions.
Yeah, Russ, so do you want to take this one? So the question that we have is, if one lawyer is suggesting mediation, and the party is willing, but opposing counsel, the other side is really pushing for court, how do you address this? How do you deal with one party saying, let's do mediation, let's do alternative dispute, but then on the other side, you know, they're like, court's the only way to go, we're going to go to court, and that's what we're doing. How do you navigate that?
Yeah, I read that question a couple ways. The parties want to mediate, but the one lawyer wants to go to court. If that's the case, I'd phone up the lawyer and see if we can even work some of the issues out in mediation or through negotiation, and try to get an understanding is why does it, this is the question I always ask myself when I get cases coming to me. Why do I need court to settle this? What's so unique about this that I need a judge's input that two reasonable lawyers with some family law experience can't resolve it? Very rarely do you require a judge's help. So I would ask the lawyer, what about this particular family do they need to go to court for? And flesh out those details. If it gets to the point where the lawyer is just being obtuse and wants to make money, then I would render offers to settle based on what I know. And if we do go to court, I would ask the judge to make sure that our costs are covered because the other person was acting unreasonably. And if lawyers are particularly obtuse, they can be ordered to pay costs personally as well. That's happened in cases, but that's sort of an extreme result where a lawyer basically needs to be disciplined because they're not acting reasonably. A great question.
Thanks, Russ. Let's see here. We have another one. What is the difference between a contested and an uncontested divorce? Okay, so that sort of falls under the what application you put forth. So a contested divorce is well, I don't want to say is exactly what it sounds like, but it is. There's something that the two of you don't agree with. And contested divorce, that typically needs the involvement of a judge or two lawyers to navigate how to, whether it's navigate support issues or property division issues, things of that nature. But most divorces, if you're just pursuing a divorce, can proceed uncontested. And that's if the two of you are on the same page about all of the terms. And that's, if only all divorces could be uncontested, but that's unfortunately, that's not the case. So that's why it's always good to have, legal representation to ensure that if there is something that's being contested, you can, properly and appropriately navigate that. Well, thank you, everyone. I know we're over our time. We're after our after hours.
Now it's happy hour, right?
Now it's happy hour for sure. But I do want to thank everyone for tuning in. It was fun. I love talking about these topics. We do it every day. So
I just want to add real quick, we have so many great resources on our website, so many blog posts written, a lot of links to the various books Russ has written, all great resources. And if anyone has any questions, relating to their matter, don't hesitate to reach out to us.
Thanks again, everyone. And
thank you, Joseph, Shanza, Steph, for working after hours and providing this service to the public. I think it looks great on the legal profession. I'm very optimistic to see such three talented, articulate professionals entering our profession. So I'm very optimistic. Anybody looking for a service, reach out to these three or reach out to a local lawyer and get some advice to help you through the process. So thank you so much, Stephanie.
100%. Thanks, Russ.
Good night, everybody.
Bye, everyone.
Good night.